So this is part 9, company law, problems and solution. Continuation. The next topic is operation and mismanagement. A company was required under a directive issued by the Reserve Bank of India to reduce its foreign shareholding from 60% to 40%. It made an offer of right shares to all existing shareholders, but issued shares only to its Indian shareholders. The foreign company, which was a shareholder, contended that non-issue of shares to it amounted to oppression. Consider the provisions of the Companies Act in this regard. 1. Explain the meaning of the term oppression. 2. Decide whether the contention of the foreign company is maintainable. Solution. The term oppression is not defined under the Act. It has been understood as an act or omission on the part of the management, which obviously implies majority inasmuch as it is the majority which holds or controls the management. It is needless to state here that though the ownership and management are distinct in the eyes of law, in reality the majority ownership and management are synonymous. Some of the principles evolved over the years and instances considered by the court as oppression are briefly given below. That is, 1. The act or omission should not only be prejudicial but also unfair, harsh and burdensome to the minority shareholders. 2. It is not unfair prejudice to the minority if it is equal prejudice to all the members of the company. 3. There has to be an advantage to one at the cost of the other for being unfair prejudice. 4. There should be lack of probity and good faith. 5. The act which otherwise in accordance with the law and procedure but malified with the intent to deny legitimate expectation of minority is oppression. And the sixth one, mere technical irregularity or illegality would not by itself amount to oppression. And relief may be granted under section 241 or section 242 only against continuous acts on the part of the majority shareholders who are oppressive to the minority. Mere isolated acts do not amount to oppression. And here in the present problem, it is based on Needle Industries India Limited versus Needle Industries New Way India Holding Limited. So the case law here is Needle Industries India versus Needle Industries New Way India Holding Limited. In this case, the Supreme Court held it not amounting to oppression. The case of Needle Industries India versus Needle Industries New Way India Holding Limited is a landmark case on the subject, and the Supreme Court's decision in this case continues to be an authority on the subject. In this case, the foreign majority alleged oppression by Indian majority shareholders as the minority appointed additional directors and issued further shares. The Company Law Board and the High Court held such acts of minority shareholder as oppressive. In appeal, however, the Supreme Court observed that even if a case of oppression fails, the court has the power to do substantial justice in the matter, and therefore, on the fact and circumstance of the case, the Supreme Court, while rejecting the plea of oppression, directed the minority Indian shareholders to purchase shares held by the majority foreign shareholders. Now, in the next question, to convert a well-run proprietary business into a private company, Mrs. Agnihotri admitted her husband as a nominal shareholder and the business prospered well. Later on, differences started showing up and Mrs. Agnihotri complained that her husband was behaving oppressively though she held 95% shares. She filed a petition before the tribunal for winding up of the company under section 241. Her husband contended that though she contributed capital, he had contributed his skill and expertise. Comment. Now, the relevant case law here is Neelu Kohli versus Nikhil Rubber Private Limited. The case law is Neelu Kohli versus Nikhil Rubber Private Limited 2002. In this case, wherein it was held that the claim of the petitioner that she had held 95% of the share capital and the respondent was taken into company merely to satisfy the legal requirement, etc., carried no conviction. In as much as mere capital alone would not ensure proprietary, and her husband contributed much by going abroad, introduced new technology, booked lucrative orders, etc. All these had resulted in quick phenomenal growth of the company. Considering all these aspects in the said case, in a proceeding under section 397 and 398, that is in the old Companies Act, and the new section 241 of Companies Companies Act 2013, the petitioner was directed by Company Law Tribunal, Company Law Board, that is the and right now it is called Tribunal, to sell out 50% of the share to her husband at the rate to be determined by the independent valuer. Mrs. Agnihotri will be directed to sell her 50% share to her husband at the rate to be determined by the independent valuer. The next problem we have is a group of shareholders holding 20% of the issued share capital in DEF Limited have filed a petition before the tribunal alleging the following. 1. Various acts of illegal, invalid and irregular transaction entered into the name of the company. Second, losses incurred due to the mismanagement by the board of the directors. Third, non-declaration of the dividends despite having sufficient profits in the past years. Examine the merits of the above petitions made under Section 241 of the Companies Act 2013 in the light of the judicial pronouncement made in this regard. So in the first scenario, that is various acts of illegal, invalid and irregular transaction entered into the name of the company. Mere illegal, invalid or irregular transaction entered into the in the name of the company do not constitute a ground for invoking provisions of Section 241 unless it is proved that they are oppressive to any shareholder or prejudicial to the interest of the company or to the public interest, and that was held in Sheth Mohanlal Ganpat Ram versus Sri Sayaji Jubilee Cotton and Jute Mills Company Limited. Once again, Sheth Mohanlal Ganpat Ram versus Sri Sayaji Jubilee Cotton and Jute Mills Company Limited. And the second scenario, losses incurred due to mismanagement of the board directors. Losses incurred due to the mismanagement by the board of directors cannot by itself be regarded as oppression. That was held in Ashok Betelnut Co. Company Limited, Private Limited versus M.L. Chandragant. Ashok Betelnut Company Private Limited versus M.L. Chandragant. Losses incurred due to the mismanagement by the board of directors cannot by itself be regarded as oppression. Now, directors' bona fide decision not to declare dividend and to accumulate available profit into the reserve is not mismanagement. That was held in V.J. Thomas Vettam versus Kuttanad Rubber Co. Company Limited. That is V.J. Thomas Vettam versus Kuttanad Rubber Company Limited. It was held that directors' bona fide decision not to declare dividend and to accumulate available profit into reserve is not mismanagement. Now, as per Section 244 of the Companies Act 2013, in case of a company having a share capital not less than 100 members of the company or not less than 1/10 of the total number of its members, whichever is less, or any member or members holding not less than 1/10 of the issued share capital of the company, subject to the condition that the applicant or applicants has or have paid all calls and other sums due on his or their share, shall have the right to apply under Section 241. In the instant case, group holds 20% of the issued share capital. Hence, they are entitled to file a petition before the tribunal under Section 241 of the Companies Act 2013. Now, the next is with respect to winding up. Now, LED Bulb Limited has made default in filing financial statements and annual reports for continuous period of 4 financial years ending on 31st March 2018. The registrar of the companies having jurisdiction approached the central government to accord sanction to present petition to the tribunal NCLT for winding up of the company on the above ground under Section 272 of the Companies Act 2013. Examine the validity of the registrar of companies move explaining the relevant provisions to the Companies Act 2013. State the time limit for passing an order by the tribunal under Section 273 of the Companies Act 2013. According to the Section 271 subclause D of the Companies Act 2013, a company may, on a petition under Section 272, be wound up by the tribunal if the company has made a default in filing with the registrar its financial statements or annual returns for immediately preceding 5 consecutive financial years. In this problem, the move by registrar of companies to present a petition to the tribunal for winding up of LED Bulb Limited is not valid as the company has made default in filing financial statements and annual returns for a continuous period of 4 financial years ending on 31st March 2018. An order under Section 273 of the Act shall be made within 90 days from the date of the presentation of the petition. And then in another question, that is Mr. X is appointed as a liquidator for PQR Limited, referring the provisions of the Companies Act 2013, advise him about the period within which he is required to apply to the tribunal for setting up a winding up committee and discuss the constitution and functions of the winding up committee. So, solution as per section 277, subclause 4 of the Companies Act 2013, within 3 weeks or from the date of the passing of winding up order, the company liquidator shall make an application to the tribunal for constitution of a winding up committee to assist and monitor the progress of liquidation proceeding by the company liquidator in carrying out the function. Winding up committee shall comprise the following persons, namely 3 persons, that is, first, the official liquidator attached to the tribunal; the second one, nominee of the secured creditors; and the third, a professional nominated by the tribunal. Functions of the winding up committee as mentioned under section 277, that is 277 subclause 5. So the functions of the winding up committee is mentioned in section 277 subclause 5. Mr. X, a liquidator of PQR Limited, is advised to refer the above provisions for setting up and working for a winding up committee. Now another question, Skyline Limited was ordered to be wound up compulsory on a petition filed on 10th February 2018 before tribunal. The official liquidator who has taken control for the asset and other records of the company has noticed that the managing director of the company has transferred certain properties belonging to the company to one of its creditor, Vansh Private Limited, in which his son was interested. This was causing huge monetary loss to the company. The sale took place in 15 September 2017. Now, examine what action of the official liquidator can take in this matter having regard to the provisions of Companies Act 2013, and determine the right and liabilities of fraudulently preferred persons by mortgage of charge of property to him to secure the company's debt. So, the solution, the official liquidator can invoke the provisions contained in section 328 of Companies Act 2013 to recover the sale of the asset of the company. So, the official liquidator can invoke the provisions under section 328 of the Companies Act to recover the sale of assets of the company. According to section 328, if the tribunal is satisfied that there is a preference transfer of property, movable or immovable, or any delivery of goods, payment, execution made, taken or done by or against a company within 6 months before the winding up application, the tribunal may order as it may think fit and may declare such transaction invalid and restore the possession. In the present problem, the sale of immovable property took place on 15th September 2017 and the company went into liquidation on the application filed on 10th February 2018, that is within 6 months of making winding up application, and such transfer of property has resulted a loss to the company. The official liquidator will be able to succeed in providing the case in proving the case under section 328 by way of fraudulent preference, as the property has sold to one's private company, a creditor in which the son of the ex-managing director was interested. The transaction made will be regarded as invalid and restore the possession of the company as if no transfer of the immovable property has been made. Now, determination of rights and liabilities of fraudulently preferred persons. So, as per section 331 of the Companies Act 2013, where a company is being wound up and anything made, taken or done after the commencement of this act is invalid under section 328 as a fraudulent preference of a person interested in property mortgaged or charged to secure the company's debt, then without prejudice to any right or liabilities arising apart from this position, the person preferred shall be subject to same liabilities and shall have the same rights as if he had undertaken to be personally liable as a surety for the debt. That is, A, to the extent of the mortgage or charge on that property, or B, to the value of his interest, whichever is less. The next problem, the company was incorporated for the purpose of manufacturing machine tools, implements, etc. it spent a substantial part of its subscribed capital on fixed asset. It borrowed a sum of 30 lakh from a bank for providing working capital. As the company was unable to pay back this loan, otherwise the stock in trade, plant and machinery and all the fixed asset of the company was sold out in execution of a decree obtained by the bank, leaving no surplus for the company. Would it be just and equitable to wind up the company in the circumstance? So the solution: in the case where subject matter or substratum of the company has gone, or the objects for which the company was incorporated have substantially failed, it was held in re Kaital General Mills Company Limited. In re Kaital General Mills Company Limited, that it shall be just and equitable to wind up the company. The substratum of the company is deemed to have gone in such a case. Now, another problem: the company liquidator of a public company in liquidation instituted misfeasance proceeding against the managing director of the company. During the pendency of the proceeding, the managing director passed away. What is meant by misfeasance? Can the legal representative of the managing director be impleaded and the proceeding continued against him? So here the relevant case law is official liquidator versus Parthasarathi Sinha. Official liquidator versus Parthasarathi Sinha. In this case, where it was held that misfeasance proceeding initiated under section 543 of earlier Companies Act and in section 340 of the Companies Act 2030 against a director of a company in winding up can be continued on his death against his heirs or legal representatives for the purpose of determining and declaring the loss or damage caused to the company. The expression misfeasance means grave breach of duty or abuse of power, usually associated with taking undue benefit or advantage at the cost of the company. However, any decision to recover money for the act of misfeasance will remain restricted to the value of its properties of the managing director in the hands of the legal representative. So that is with company law problems and solution. This was the final part. Thank you for listening and stay tuned. So we'll be updating other law subjects and related PYQ and problems and solution discussion. Thank you.